In this case, where I have checked the office note,
Mm.
service report of the respondent is awaited, my lord. So I pray that another
Item? Item
item
46.
46, my lord.
Okay. Service on respondent number 2 is not yet complete. Await. List
My
again.
lord, one, in respect of one, my lord.
1. Okay. List again on. Give a date.
Let it come after
After 2 weeks, give a date.
46.
Oh,
Much obliged, man.
hey, PJ Lordship. With the consent of the other side, I beg to mention item number 57 and 58. It was some medical emergency, Your Lordship, so and personal difficulty. Only matter taken on Monday, Your Lordship. Item supplementary list, Your Lordship.
57, 58.
Okay.
Okay. The prayer of learned counsel for the
The petitioner-
petitioner and with the consent of the respondent. List the matter again on. Give a date.
Sorry. Lordship.
Well, item number 29.
Yes.
I'm told my CD was not there, man.
He did not mention moment. No.
Item 29.
29.
They did not receive list again on.
Needed.
Yeah.
Interim may be continued.
PP. Date.
24, interim is there.
Interim to continue.
Alright.
Okay.
Wait, please, your lordship. I
Mm.
beg to mention item number 31, lordship. Can the matter may be adjourned for 1 week, lord? Learned, yeah.
Learned prayer of learned counsel.
But when we have received the case diary.
Huh?
We have received the case diary.
List the matter. Again on, give a date after 1 week. CD received,
Cannot-
be retained till then.
We have required to submit our up-to-date case diary. So case diary, yeah, he received not up-to-date. So we have to send back the CD for updation, Lordship.
It is submitted that the CD received is not up to date. Hence, CD be sent back and up to date CD be submitted by the next date fixed.
24/11, Lordship.
List again on 24.
Twinkle co-
Interim order passed earlier shall continue till the next date of listing.
Obliged.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 13, lordship.
1-3.
Lordship, I am for the respondent
Yeah.
appearing on behalf of Mr. R.S. Mr. Is out of station here, Lord.
On prayer of learned counsel for respondent number 2 and the consent of the petitioner. Place the matter again on.
May I please, lord?
Right, your lordship.
First, I beg to mention item number 56, Lordship. In this matter, contacting counsel, Mr. S. Samaria is not available. Lordship. Because some personal difficulties is there, Lordship. So I am preparing for adjournment, Lordship.
Lordship, I am for the respondent in this case. The matter may be taken up on next week, Lordship. Any date may be fixed.
All right, on the prayer of learned counsel for the petitioner and with the consent of the respondent, list the matter again on. Give a date.
11, Lordship.
11.
Even his senior also,
Yeah,
All right, 11.
interim order is there, Lordship.
Interim order passed earlier to continue till next date of listing.
Highly recommended.
Beg with your lord. The consent of other side, I beg to mention item number 65 of supplementary list. In this case, the teacher is yet to be received, lordship.
Item 65, TCR is called for yet to be received.
Next week, lordship.
Issue reminder. If the TCR is not here by next week, we do not know if it will
Yes,
be
yes,
here,
we
so
do
that
not.
it be after 2 weeks. Date after
Lordship,
2 weeks.
before 19th, any date,
Huh?
before 19th,
Before 19th.
18th, lordship.
Okay, 18.
Obliged.
Wait, please, your lordship. With the consent of other side, I make item number 12. Kind number 7. I am appearing on behalf of this.
Lordship, I am for two.
When do you want?
Yeah, adjournment.
Yes, on the prayer of learned counsel for the petitioner and with the consent of the respondent. Is the matter again on?
It is.
Yes.
Master.
May I please your lordship? I beg to mention item number 14, 14.
Hmm.
The case diary has not been,
Yes, they not received, Lordship. So he's an interim, Lordship.
I'm on interim.
14 CD not received. List again on so and so interim order. Passed earlier to continue till the next date of listing.
25th, 25th,
25th 11.
DP of line.
May I please your lordship? Beg to mention item number 47. Kindly pass over.
47 passed over for the day and the prayer of learned counsel for the petitioner.
May I please your lord? I beg to mention item number 60. Supplementary. And
Yes.
pass over for today, lordship. Fixed next.
Same order passed over for the day.
May I please your lordship, lordship with consent from other side, I beg to mention item number 7,
17.
17, lord. Matter may be adjourned for 1 week, lord.
Prayer of learned counsel. Consent of the respondent is the matter.
Next,
14 is next week, I think.
lordship, another prayer pertaining to the same item number, lordship. Lordship, in the index, there is some typographical mistake of pagination, lordship. May I allow to correct the same, lordship? Page number, lordship.
All right, do it.
Much of it.
Your Lordship, I beg to, it's an item number 36, my lord. The petitioner wants to withdraw the case.
You are
Yeah, petitioner, I'm NP Dwara, my.
the prayer of Mr. N.P. Duara, learned counsel for the petition. This is dismissed as withdrawn. Yes. Follow up.
Petitioner want to withdraw the case.
Withdraw.
Yeah, Your Honor.
Okay. Your name?
NZ Ahmed, Your Honor.
Prayer of same order. Donate.
May I please your lordship? It is not this time being. Pass over
Password for the time being.
May I please your lordship? Lordship 1031 of the PNS, lordship.
CD?
Yes.
Lordship today 39 days.
Bongaigaon. 21, Lordship. 21/11. May it please your Lordship. FIR at page 50, my lord.
Hmm?
FIR at
Yes. What is the allegation?
allegation, my lord, if I may read out the FIR, my lord. 1032. 1032, my lord.
So it's 103.
Yes, 103.
CD.
21/11. 21/11.
May I please, lord? Have a look at the FIR, madam. The FIR, my lordship, have a look, madam. Completely consensual, once it's around 16, madam. Page 15 is the FIR, madam.
15. Page?
15, madam, translated copy, madam. May I read, madam? It's 17, they were in a relationship. Supposed to get married, my lord.
How many days?
35, 33 days as on date. What has happened, my lord? He has hid the fact that there was a ring ceremony, my lord. With NX photographs, the ring ceremony was done on T223, my lord. Thereafter, she left for Gujarat, my lord. The ring ceremony photograph NX is page 24, my lord. Thereafter, my lord, she alleges that her pregnancy was aborted, my lord. It was allegedly in the year 2023, my lord. No complaint, my lord. If it is done with her consent, my lord, it'll be section 88 of the BNS, my lord, is bailable, my lord. And I'm in a relationship with her since the year 2017, my lord. Marriage was supposed to be solemnized, my lord. However, she allegedly had an affair, my lord. I have annexed her call logs, my lord, her phone details, my lord. You will see she talks to another boy. The name of, I will not say his name, my lord, he's not before your lordship. Continuously, my lord, the call logs are annexed at page 95, lordship will see, my lord. This is her number, my lord.
Page?
95, my lord. This is her number, my lord.
Hmm.
Page 96 is the number of the boy, my lord. The other boy, my lord. Page 97 is her call log details, my lord. Lordship will see at the top right hand side, my lord, geo number, my lord, so and so. 88223.
Okay, after that, what happened?
After that, my lord, since I found out, my lord, that she is doing this to me, my lord. Obviously, the relationship soured, my lord. And then I also lodged an FIR, my lord. Should kindly have a look at the FIR, my lord. Page 81, my lord. Since I'm a boy, my lord, nothing is being done, my lord. This FIR is much ahead of the instant FIR, my lord. The instant FIR is 51025, my lord. This FIR, which I lodged, is 26825, my lord. Page 81, my lord. Before the in charge of Ramdev police outpost. The entire story is narrated. Maybe, my lord, no cognizable offense is made out, but she has been threatening me since long that she will commit suicide and everything. Everything I've mentioned, my lord. Police has done nothing on my FIR, my lord. It is only they've received it, given me a GD number. Thereafter, my lord, since they did nothing, my lord, I again lodged another FIR with the officer in charge of Hajo police station, 16925, my lord. That is page 86. Again, only one thing they did, my lord, they received the copy, my lord, and nothing else, my lord. Subsequent to this FIR, second FIR that I lodged, my lord, the instant FIR has been lodged. Save her face in society, my lord. I helped her out with the finances, my lord. I have annexed money receipts. I opened this restaurant in her name, my lord. I have annexed the rent agreement, my lord. Everything was done out of care and affection. Thereafter, when the subsequent event happened with the other boy, my lord, the relationship soured, my lord. Now I'm behind bars for around 33 days, my lord.
How many?
Behind bars for around 33 days, my lord. And the only allegation of abortion, my lord, is in the year 2023, my lord. No complaint for 2 years, my lord. Section 88 is bailable, my lord. Kindly say section 88 once. Please.
She became pregnant twice during that period, lordship. And yes, she was forcefully aborted her pregnancy.
They forcefully aborted, my lord, and then complaint should have been in the year 2023, my lord. Why wait for 2 years? I'm such a bad person, my lord. Forcefully getting a pregnancy aborted, my lord. Subsequent to my 2 FIRs, my lord, she lodges this FIR, my lord. But you can see the call log details again, my lord. Page 98, down below, my lord. Continuously, my lord, for hours and hours, she talks to this boy, my lord. You kindly see, my lord, 57569 is the boy's number, my lord. Page 98, down below, my lord. For 94 minutes or 135 minutes. How is this possible, my lord, when somebody is in a committed relationship? My lord? Thankfully, the family members could find this out, my lord. It always happens, my lord, when a relationship sours, my lord, the boys at the receiving end or everything, my lord. Humbly pray, my lord.
Yes, PP. Any point? Calling.
Promise to marry and
Huh?
promise to marry and cheating and other. Only thing is that, lordship.
Third learned counsel for the petitioner and learned additional PP decision application on the joint so it appears from the FIR that the informant lady had been in a relationship with the petitioner for several years. And in course of such relationship, the informant became pregnant twice and underwent abortion at the instance of the petitioner. It also appears that an FIR had been lodged by the present petitioner against the present informant. Which page is that?
Page 81, my lord. Ramdia Police Outpost GD entry number 406 26 8.
Wherein allegations have been made that the informant, despite her relationship with the present petitioner, was in constant contact with another person named in the said FIR, because of which their relationship soured. This led to the lodging of the present FIR. The petitioner was arrested on
My lord, 6/10/25.
and by now he has already spent 33 days behind bars. Having regard to the facts and circumstances outlined above, further detention of the petitioner is not considered necessary. Accordingly, petitioner shall be released on bail of ₹20,000 with one surety of like amount. Thus, satisfaction of the learning
JMFC Hazo Kamrup Haminga.
in connection with the aforesaid case.
I'm highly obliged, Lordship. Obliged, Lordship.
Please, your lord. This regular bail application, lordship, the petitioner is in custody, lordship, as on today, 105 days, lordship, and court is already grant bail, all the court is, lordship, kindly come to page number 22, lord. Tab 22, lordship.
Where is the FIR?
FIR is, lordship, page number 10. Apart,
105
lordship,
days.
page 10. And particular page number 14, lord. So already, all the accused already grant bail, lord. I have annexed the order, lord. And other order, lord. All the court is to grant bail, lord.
Where is the
Another-
order?
Order, lordship, page number 22, lordship. And I have provided the another order, lordship, and they are also done. Except the
Your
other-
name is
Lordship,
Fazal Haq.
lordship,
105 days.
105.
That's it.
Charted.
That's it. This order, after submitting charge sheet, lordship, they are grant bail. And para number 4, lordship, kindly come to page number 20 and page number 20. All are grant. He is in the story.
Yes, PP, what to do? Parity,
Lordship,
all granted bail.
all granted bail. After filing of charge sheet also, one person is granted. Lordship.
देखो सुनो सेम ऑर्डर
Deeply obliged, lordship. Deeply obliged.
May I please, your lordship? The regular bail application. My lord will please to find the FIR at page 15, my lord.
yes
Lord got it?
Yes,
My lord. I wish to lodge a complaint against members of the Bir Lassit Hana regarding their continuous systematic and organized criminal
you
activity.
are going to read the entire FIR.
No, my lord, not necessary because the first 5 paragraphs are nothing. It's just an improbable allegation. My lord, from the paragraph number 3rd from the bottom, my lord, I'm reading from that. Furthermore, the individuals and their organizations have with deliberate and malicious intent misappropriated the revered name of the Mahabir Lassit Borphukan. This act appears calculated to deceive the public by clocking their criminal activities in a fraudulent veneer of patriotism. It is also reported that on or around 25th October 2025, this is important, my lord. On or around 25 October 2025, members of the organization held a press conference in Nalbari, deliberately promoting disharmony during this press conference. Hostile statements and threats were allegedly issued against the Hindi-speaking population of the Nalbari district. This inflammatory action seems calculated to incite hatred, create fear, and foment social discord, challenging the peaceful coexistence of the community. During the press conference, public threats were issued, ordering the Hindi-speaking community to refrain from observing their Chhat Puja festival. Further prohibitions were declared against playing Bhojpuri songs, acts prejudicial to public harmony. Such actions represent a flagrant and unlawful interference with the community's constitutionally guaranteed religious and cultural rights, constituting a deliberate attempt to intimidate and marginalize a linguistic minority, thus disrupting the unity and integrity of India. It is therefore urgently requested that this affair be registered and a thorough investigation is NHS so and so. Basically, the allegation is, so they had a press meet on 25th of October, that organization, the allegation is that. So regarding this present petitioner, my lord, he is not a member itself in that organization because he has resigned from that organization in the month of May itself, and he was not present in that press meet itself, my lord. The resignation is, my lord, will please to find at page 20, my lord. My lord, got it?
Page?
20, my lord. He has resigned from his post. Earlier he was there, yes. So to the Honorable President, Bir Lassit Hana, Nalbari District Committee, so and so, dated 19/05/2025. So with due respect, I would like to state that I officially became a member of Bir Lassit Hana, Nalbari District Committee on 18 September 2024.
Right.
Despite my busy schedule, I tried my best to contribute to the organization as much as possible. However, due to work pressure and lack of time, I hereby tender my resignation from the post of general member of Bir Lassit Hana, Assam so and so. So on 19/05, he has resigned from that organization.
When was the press conference held?
It's allegedly on 25th of October 2025. And the new committee has,
Allegedly. I don't know if the press conference was held.
but I don't know. Because I was not a member itself. And my lord, on 2nd of September, a new committee was also formed. My lord will please to find at page 22.
Your designation was earlier?
Yes, yes.
No, no, what
19/5,
was
my
your
lord,
earlier
May.
designation?
May, my lord.
Earlier designation.
Working president.
Yes, yes.
Yeah, it's I prefer case jail or just short date.
My lord,
After
the
president
new
of case
committee
jail.
is on 22nd. The new committee formed on 2nd of September 20. My lord will
Yes,
please.
when can you get case diary?
But six-
When were you arrested? 30?
Yes, my
detail,
lord.
up to 7 days today.
Only 7 days.
Lordship on 18 lordship,
Yes, why that?
14 then, 14 lordship.
All right, 14. CD.
Much obliged, my lord.
I believe.
Yes.
Report was called.
Okay. So report was called for Lordship in the earlier date, Lordship. We have not received the report, Lordship. In a short date, we'll try to produce the report, Lordship. From Nalbari PS.
Report as called for has not been received. Learned additional PP to obtain the same
1811, Lordship.
by the next date fixed list again on 1811.
I please your lordship, bail application under section 482, charge sheeted case. FIR at page number 9, lordship.
What is the allegation?
5 copies, page number 11, 376. Kindly see page number 11 is size, Panaguta to be page 12.
TCR scan copy.
Matter is pending before the learned EGM lordship for committal stage.
Huh?
For committal stage pending before the learned.
Okay,
EGM.
we'll have to see the serial. TCR.
AB 20 lots.
I didn't mind.
Where please? 482 application. FIR is at case 8 lots. Allegation is that I have been making obscene sister through messages and pretending over telephone to her. The allegation.
Yes, PP.
Lordship, my respectful submission is, Lordship, they should approach the concerned court below first. As per the latest Supreme Court judgment, Lordship, it has been categorically stated that they should approach the learned court of lower court, Lordship. After that, they should approach the high court, which they have not done. Instant.
In that case, we must dismiss all the,
Lordship,
in that case, we must do away with the entire list now.
if Lordship permits me, then I can place that judgment, Lordship.
But there are other judgments also
Uh,
to
latest
the
judgment,
contrary.
The high court could not entertain the first instance, Lordship.
Yes, I was very happy to read the judgment.
Yes. In any case, Lordship, TD may be called for. Lordship.
If I may be protected.
All right, we'll call for the CD as of today. We'll decide that issue on the next day.
Lordship, two sections are bailable, Lordship. Only one section is non-bailable.
Yes, otherwise this would not have lied.
Date to 20. 11.
Wait, please. Not this repeal, my lord. FIR is at page number 8, my lord. There are 5 numbers of accused persons. My lord, the petitioner before lordship is accused number 5. And accused number 1, 2, and 3 are already been granted bail by lordship. Lordship page number 8. The allegation is there was a quarrel between the Zubin followers. The petitioner is also a Zubin follower, but a quarrel was taken place. 5 numbers of accused person. It is alleged that there was a quarrel with the thousands of people who appeared in the rally, my lord. However, my lord, rally is over, my lord, all the funerals and etc. are over. So there is presently there is no dispute, my lord. So lordship has lordship's order page number 17. 3 numbers of persons are allowed to go, my lord. So lordship may dispose of some with some condition that I will appear as it may required, my lord. In 7 days or 10 days, my lord, I can appear, my lordship. Vernacular page number 12. Page number 17 is the order. Lordship. It is already settled, my lord.
It is your name Dulaluddin.
Dulaluddin, accused number 5.
Accused number 5.
Same footing.
Same footing, man. Actually, his name is there, but no allegation is there in the FIR. It is stated that one person's shop was closed, open, that is the allegation. So the other person has already been granted. May I pray the similar order?
All right, let's dispose of this since others have been. Page 17, order. That was in regular bill, this pre-arrest bill. Paragraph 1, 2, 3, 4, 6. Seven. Then you write, having regard to the arrival conditions, I am of the considered view that in the facts and circumstances of the present case, the custodial interrogation of the petitioner is not necessary. Accordingly, the prayer for pre-arrest bail is allowed. So in the event of his arrest, 20,000. One surety. Conditions, same.
Deeply applauded.
After sentence.
With lordship. FIR page 10 lordship. 10 lordship, FIR says lordship that informants physical disabled daughter lordship, she got 5 months pregnant. Lordship, they say that lordship, she also indicated my name lordship. That's why lordship, they FIR. So lordship, my part is that.
Which list is this? 54.
What is the ground lordship? I am totally lordship, I am denied lordship, I have not done this lordship. I am not disputing the office lordship. This may be done by another lordship. But the conduct of this are 2 persons of the villager lordship. Well, I can say that lordship, this might have done by some other lordship. My clear statement lordship, I have never done this lordship. And what is the conduct of the lordship to villager lordship? They lordship repeatedly claim lordship some money lordship from me lordship. And I denied lordship. That's why the FIR lost lordship. And lordship, prior to the lordship, I got the information lordship that the said 2 persons lordship also claimed the money lordship from other person also. And 2 persons already paid the amount lordship. That's why their name is not in the FIR lordship. But my name is lordship, just included lordship. Because of lordship, I did not pay any money lordship. And lordship, I repeatedly claimed with the villager lordship to have the DNA test lordship, to ascertain the fact lordship. As I have the full confidence, I have never done this lordship. But lordship, the police says now lordship that before the delivery of birth of child lordship, this cannot possible. That's why lordship, they are not doing the DNA lordship. But police lordship, they got full information lordship from the villager lordship that say 2
All right, CD.
Lordship, interim may be granted, Lordship,
No,
short date may be given, Lordship.
21.
Lordship, kindly have it some date, Lordship, because I am in travel, Lordship, now please may arrest me also. Lordship,
that
18, 17,
15,
17 Monday, 17,
17, okay. Oh, Lordship.
17.
Is it- This is an petition for regular bail, my lord. The petitioner has been arrested on 22nd of October, my lord.
pardon?
At this stage, the petitioner was arrested on 22nd of October, my. And he is behind the bar now. My lord, at present, case diary may be called.
All right, CD.
A short date may be given, my lord.
Yes.
Right. Lord, this is Lord, PRS bail application and Lordship will find page 8 is the Lord affair. May I read this Lord affair?
Hmm.
Lord, with due respect, I most humbly submit that for the last 8 and 9 months, the accused person named below used to come to our house to give tuition to younger brother. And I also used to learn certain things from him whenever I need to understand. From that time, North love relation gradually developed between me and state accused person. Thereafter, on 1/9/2020, at about 5 p.m. in the evening, the accused person came to our house, my younger brother, and on that day at 8 a.m. night after completion of the tuition, when my younger brother was then the accused person, and while touching my body, my mother's other and shouted, on which the neighboring came and apprehended the accused person. In connection with the case, the family members of the accused person, along with the prisoners, held a social meeting, and in that meeting, they gave a written assurance that the accused person.
Yes, PP, why trouble ourselves with these cases, CD and all?
Since Mulata, there is no Mulata.
We had learned counsel for the petitioner and petitional PP. The allegation against this is an application under so and so. This is the allegation against the petitioner is that he was in a rough relationship with the informant. He is a major.
This measure.
Who is a major guard. And when the same was discovered, a written assurance was obtained from the petitioner that he would marry the informant, but informant on 03/09/25. But after passing of the said date, the accused person left home and kept his phone switched off. From the contents of the FIR itself, it appears that the petitioner was made to give an assurance of marriage under duress. Having regard to the nature of the allegation, the prayer for prior's bail is allowed. 20,000 once here it is.
Development.
May I please your lordship. In both the cases, lordship, case diary was called. And in both the cases, petition.
It has been received, Lordship. Your Lordship, item number 16 is AB, Lordship. He was granted interim protection, Lordship, but the records are not updated. So in that regard, my prayer will be for updation of D. Now, Lordship, in regards to item number 15, this is DA, Lordship. His involvement is there, Lordship, but not to that extent. First warrant further detention. If Lordship, can you peruse the case study? Oh.
After completion of 50 days,
50.
50 interim was
Third
done.
learned counsel for the petitioner. It's also learned additional PP. Is this other bail order? Amzad Ali?
Amzad Ali was number 1, Lord. He was granted bail earlier. This is his interim bail.
Present petition is equal.
Same police case.
Same FIR.
Amzad Ali.
Yes, Lord. He was the accused number 1 and Ukaluddin accused number. That is
Already heard Mr. So learned counsel for the petitioner and Mr. Learned additional PP. This is an application on so-and-so. What is your date of arrest?
He was arrested on 8/8/2025.
The accused is stated to have been arrested on 8/8/2025. It is submitted by learned counsel for the petitioner that he has already spent how many days? 50 days.
50 days.
50 days behind
Days,
bars.
Lordship, when the interim order was passed.
And he's on interim bail now.
Yes, Lordship.
50 days.
Interim was granted
Whereafter
on
he had already spent 50 days behind bars. Whereafter he was granted interim bail
on 26/9/2000.
on by order dated 26/9/25, passed in
Number 308.
in the instant case. In the instant case. Full stop. On perusal of the CD, it appears that the material against him is not such as would require his further detention. Considering the same, the prayer for bail is allowed. The order of interim pre-arrest bail dated 26/9/25 is made absolute, subject to the same conditions. Petition stands disposed of. This is in item number
15.
15. Item number 16, Learned additional PP submits that updated CD is not available. Accordingly, the CD received be sent back and updated CD be submitted by the next date fixed. Till then, interim order passed earlier to continue.
24,
List again on
24/11.
Any other day?
25.
25. Highly obliged.
Please, your lordship. Here, TCR was called for lordship. Even then, lordship, the petitioner is behind the bar for 108 days. And matter is charge sheeted and charge has been framed and 2 witnesses have already been examined. So I have got the certified copies of the witness. মারামারি
not received.
not received. 108 days lordship. Witnesses lordship, I have the copy of 2 witnesses lordship that are certified.
Yes, pass over.
charge sheet had all, already been annexed in the petition. Supreme order. Supreme order is also annexed in the petition. Yes. Put the witnesses, one is victim, the mother, and another is on lordship, or the place of occurrence, is different place.
So the evidence implicates you.
So, but the place of occurrence, lordship, is two different. Victim says one another place, and the witness, lordship, the son, he says different place. Whatever it may be, lordship, local person will appear. The charge has been framed under 126(2) and lordship 1182, lordship. Local.
What are those?
Lordship, 126(2) says wrongful distance and 1182 says grievous hurt. But not so serious, lordship, already been released from hospital after 2 or 3 days, lordship. Everything is there, lordship, no chance of hampering or tampering with the witness. Also, charges of claim, lordship, 2 has been already examined. Actually, both are neighbor, lordship. Regarding some monetary dispute, lordship, this quarrel took place, and the informant, lordship, one got injured, lordship, father. Will face the trial, lordship, will nearby the that locality. Both are neighbors. One 108 days, lord. So page 28 is the lordship transfer model of my petition.
The place of occurrence is widely divergent between the two witnesses.
Lordship. Nearby person, lordship, not habitual offender, lordship. Some dispute was there, lordship, fighting was there. It is an admitted position of fact. I'm not denying to that. But regarding that injury, how far, lordship, that will determined by the medical and lordship, the evidence of the doctors.
Yes, PP.
Only the injury part is there, lordship, that harm
Injury part is there, but
or an implication by the
two witnesses, husband and wife, place of occurrence is totally different. One says it's in the house of the accused, other says it while they were going to a construction site. Totally different. Rest of the story is same.
lordship.
Although we should not comment on the evidence at this stage. I'd learned counsel for the petitioner, additional PP. PCR as called for has not been received. This is an application under so and so. The allegation is that paragraph 2 of the bail petition. The case has already been charge sheeted and the evidence of the two principal witnesses have already been recorded. And in the meantime, the petitioner has spent how many days?
108.
108 days behind bars. Where I have perused the evidence of the principal witnesses. Without commenting further on the merits of the evidence, it appears that the further detention of the petitioner is no longer warranted. Accordingly, the prayer for bail is allowed. 20,000 till the satisfaction of
Yes. Sir, trial court lordship,
the learned trial court.
trial court Borpeta.
The certified copies of the evidence submitted by learned counsel be kept on record for ID.
Much obliged, sir. Much obliged.
Thank you. Your lordship. The other day matter came up before your lordship, but your lordship asked me to bring the details order of the bail court granted. But in this case, earlier one have already granted one accused person by the Honorable High Court, and the Lane Session Court also other accused matter. Today I am 38 days behind the bar matter. We have not received a case, their case. Huh? He didn't. But 38 days already I am behind the bar matter. And
What is the allegation?
well, my name is not there, but I have not done one matter. Nobody
Your name is?
was given a car on hire. He has sold on rent matter. He has sold it out in Manipur matter. I am Harsh Sharma matter. Monish Jyoti Das was given the vehicle matter on rent matter. No forwarding, could my. No forwarding.
Forwarding is there, page 22.
The
And
forwarding-
this is regarding only
Devjit Sharma and Sima Sharma.
Sima Sharma. Where is your forwarding?
It is Harsh Sharma, Lordship. The case diary, I think it's very difficult to say that what is the involvement. Harsh Sharma.
That is what I am trying to find out by reading the forwarding report and all,
But I have-
where you have come in.
Yes, yes. Harsh Sharma is there.
So you are the brother-in-law of Deep Roy, Adar,
Yes, yes.
and involved in the same business.
But the vehicle was not gone from my hand. It is Manish Das, man, who has taken the vehicle from the informant on rent. Regularly they will pay, but he has sold it out. Now police on suspicion that we are also involved. 38 days behind the barment. And a similarly situated person have been granted bail by the Honorable High Court and the Lane Session Court. Already told you that it may be organized crime, so racket may be operated in this. Nowadays, everything is organized crime. That is the problem.
These are also, others are also similarly situated.
Similarly situated.
They've been granted bail on basis of length of detention.
Lordship.
I'd learn Mr. Sibissa's learned counsel for the petition and learned additional PP. This is an application under so and so. The allegations as disclosed in the FIR order dated 17/10/25 of additional sessions, paragraph 4. It is submitted by learned counsel for the petitioner that there is no involvement of the present accused and the co-accused have already been granted bail. Co-accused, namely Mainu Tonbi Sharma, has been granted bail by the learned additional session judge number 2, Kamrup Metro, by order dated 17/10/25 in bail application number 958 of 2025. Further, This High Court has also granted bail to another co-accused, namely
Hima Sharma,
Seema Sharma by
PA number 3204.
order dated 26/9/25 in BA number 3204. Where the the forwarding report in respect of the present petitioner has been furnished by learned counsel for the petitioner, which is kept on the record. The perusal of the same would indicate that the present petitioner was arrested upon being implicated by the co-accused, and no other material is indicated in the case diary, and no recovery was made from the present accused. Having regard to the fact that the co-accused of the case have been, having regard to the above, as well as the fact that the co-accused have already been granted bail, considering the progress of the investigation and the period of detention, which in the case of the present petitioner is 38 days, the prayer for bail is allowed. Accordingly, accused this is name Harsh Sharma is directed to be released on bail of rupees 50,000 with one surety of life amount to the satisfaction of the learned.
CGM compromise.
Say Alaka Magistrate.
Yes.
Magistrate. Subject to the following conditions. Paragraph 8 of this same order. Mainu Tanvi Sharma no, it is Shibajit Sharma. Shibjit, SHIBJIT. Bail petition stands allowed accordingly.
No problem.
Item 21. And copy call question. Scan copy or call for all. It is not received in the.
Four days, my lord, behind the bar, my.
Hmm?
Today, my lord, 54 days, my lord. That is 9, my lord. And my lord, committed suicide. My elder brother is staying at Dubai.
Who are your husband?
No, my lord, I'm the younger brother of the husband. Entire family has been named in the FIR.
Very difficult to say without postmortem report.
Record not received yet.
This is registered under section
82, my lord. Saudi death, my lord.
Okay, when can we get it?
Can copy to stay next.
On Monday, my lord.
हो जाए होता है
Where is it coming from?
From Uzaiman.
Hmm?
Uzaiman, Doboka.
Yes, PP. Can we have it?
CDNF can copy to destination received
As per my instruction, my lord. Yes, and my lord, but
in the office note it was reflected or not. But I
it may be taken on Monday, my lord.
office note
Actually.
was citation scan copy I see. I had next month
Awaited.
awaited.
On Monday, my lord.
Scan copy of
Thank you.
PCR not received issue. Registry is directed to issue reminder. List the matter again on
90.
And
Monday को सेवन नो
11.
11 को 11 के
Right.
21 same order.
We were arrested on, first we were arrested on 27, 2025. Subsequently,
Received.
not received lordship. You have not received
Yes.
the case there also.
this, on 27/7/2025, we were arrested. Subsequently, we were shown arrest in subsequent 3 FIRs. In all of them, we have been granted bail. This is the only FIR that is left. In this, we were shown arrest on 10/9/2025, and today is 57 days. The statutory period is of 60 days. As a whole, we have been in behind bars for 102 days. Bail may be considered. The FIR is at page 22. For theft is 303(2). The offense the punishment is only of 5 years. We were also in remand for 2 days. At this stage, bail can be considered. 57 days.
Heard learned counsel for the petitioner and learned additional PP. Seat is called for has not been received. This is an application under so and so. The allegation as contained in the FIR is that paragraph 3 of the bail petition. Earlier, the petitioner was arrested in connection with which case?
Your Lordship, the bail order is at page 12. In connection with Sutia PS case number 79.
79 of 25 under section 303 within bracket 2 of BNS where he was granted bail. But he continued to remain in detention as he was under arrest in connection with
Another
another case that is
Viswanath Chayali PS case number 134.
134 of 2025 under section 303 2 of BNS. In which case also he was granted bail by order dated 25/9/25 in bail application 3099 of 25. But in the meantime, the instant case was lodged where he was shown arrested. Is that correct?
Yes, Your Lord. There's another FIR, Your Lordship, of York PS case number 95,000, in which Your Lordship has
There was another case against the petitioner being TO PS case number
95 up to 2025.
against the accused. And in that case too, he has been granted bail by this court. the petitioner was shown arrested in the present case and reckoned from the said date, he has spent 57 days in custody, while the period of statutory detention is 60 days. Moreover, the petitioner has cumulatively spent how many days?
102.
102 days behind bars. Where it is expected that the investigation could have progressed during this period. Having regard to the above, the prayer for bail is allowed. $20,000 one surety, subject to the condition that he shall not hamper the investigation or tamper with the evidence and shall make himself available during the trial. Bail petition stands allowed and disposed of accordingly.
Much obliged.
We have not received a case there. Yeah, please, Your Lordship. But the petitioner is a lady, my lord, and 52 days in custody, 60 days the my lord, statutory period, my lord. And kindly see the affair, my lord, case 9. Allegation, my lord, against my husband, my lord. Allegation of kidnapping, my lord, the victim already has been recovered and his statement has also been recorded. Recovered. Yes.
How many days?
Well, 52 days and 60 days is my lord statutory period. And my lord, I have my lord 2 children, my lord. One my lord is going to appear SSLC examination, my lord, and another is reading in class 6, my lord. So my lord, kindly consider my lord length of detention because my husband was allegedly involved, my lord, but there is a monetary transaction actually, my lord. So I am not on that, my lord. But kindly consider custodial.
Heard learned counsel for the petitioner and learned additional PP. CDS called for has not been received. This is an application under so and so. The allegation as contained in the FIR is that paragraph 3 of the bail petition. It is submitted that the allegation is against the husband of the petitioner, who is a lady having 2 minor children. And no such involvement on her part is reflected in the FIR. And in the meantime, she has already spent 52 days in custody. Having regard to the above, the prayer for bail is allowed. 20,000.
As far as statement victim is recovered.
It is also submitted that the victim has already been recovered and his state has been recorded. What did you? I got paragraph 2. This subject to the condition that the petitioner shall cooperate with the investigation, shall not try to tamper with the evidence or influence the witnesses. Bail petition stands allowed and disposed of according.
I love this. I love that.
Yeah, Your Lordship. Yes, that was called for. FIR case 9.
Not received.
On 21/9.
Receipt.
25 Lordship. FIR case 9. Vernacular test 12. In this case, I received lordship, only thing is that PM report not received yet, but on the arrested accused, Amol Borwa, he has, in his confession, he has confessed that he has he hit and killed the victim, lordship. Going to the case diary, I have not found any sufficient materials against this petitioner, lordship. Lordship can peruse the case diary also. Arrested accused Amol Borwa has confessed and he
Let
has
us await the PM report.
PM report. PM report is awaited.
Yes.
CDS call for has been received, but PM report is not available therein. Call for the PM
It's
report. list
46
again.
day on this custody, lordship.
Call for the PM report.
1811.
Obliged, lordship.
Please, Lordship, item 27.
7 to the.
Executive.
Must follow.
Twenty-five, 26, no? Lordship, updated CD, we have not received the update. So CD may be sent back and updated.
Learned additional PP submits that up-to-date CD has
In time of-
has not been received. And hence the CD be sent back for resubmission of updated CD. List again on so and so. Interim
2511.
order-
Interim shall be continued.
Order passed
25
earlier to continue till the next date of listing. Same order in all three cases.
All three cases, 25, 26, 27.
Hello. Is your Lordship?
রিটেন করলে আপনার সিডিখন আছে কিন্তু রিটেন করলে আপডেট লাগিব মাত্র আপডেট না 25 তিনটাতে we have not received the case diary lordship. Up-to-date CD was called for, that is not received yet lordship. Is an interim lordship. Interim lordship.
To-date CD not received. List again on so and so interim order passed earlier to continue.
This case since 28/4/2020.
So should we vacate the interim order?
On the 27/10/2025, strict order was also passed by this honorable Lordship. Or
Earlier CD was received lordship, but it was sent for updation, that is not received yet lordship.
Yes, next.
The next date is lordship 24/11.
Last occasion, skill group of the case diary. Legal report was called.
In this case, lordship charge sheet submitted.
So, Lordship,
The
pending
scan
case
copy was also called for.
Yes,
A scan copy was called for.
Not received.
Scan copy not.
All right, same order, scan copy not received. Interim order passed earlier to.
That the ST by অলপ দেৰিকে দিয়ক কাৰণ আহিব লাগিব ন। Petitioner is an interim lordship.
Interim.
So I have made a prayer for another date lordship. He did not receive.
Not received. Interim to the.
When
Any instruction,
Not
service?
service report lordship, after some time we taking.
3 and 4, respondent number 3 and 4 has already entered appearance. Respondent number 2, lordship, is the police officer, he is wrongly lordship.
Police.
Yes. So my friend can do.
Then he
it,
can
or
appear.
He may not be the necessary part.
Learned counsel has entered appearance for respondent
Is it
number
possible?
3 and 4. Respondent number 2 is a police officer who can be represented by learned prosecution. Hence, list the matter for. What is this for?
CD not received yet lordship. If received, then we have to take instruction whether received or not.
And on the last day, city received, lordship, respondent did not appear, one of the respondents. Can it be taken up at 2 p.m. lordship? My friend can obtain instruction. It is perhaps available in the PPs. On the last day, city received.
So we have to take instruction lordship after some time, lordship.
After some time.
Yes.
Your lordship, we are on interim.
CD is received.
After investigation or call for earlier order lordship, but they have appeared before IO after getting interim lordship. For the postmortem report.
This is the FIR, page 18.
Lordship. Page 18 is the FIR lordship. So page 18 is the FIR lordship. Lordship, what has happened, lordship? A boy committed suicide, lordship. Thereafter, we have informed the concerned police station. A UD case was registered, lordship. After 3 or 4 days of the alleged incident, lordship, the father of the victim lost his FIR, lordship.
Cause of death is hemorrhagic shock as a result of lung injury caused by heart and blunt force impact. All the injuries mentioned above are antemortem in nature and caused by heart and blunt force impact. So witness said that he has run out to upstairs and committed suicide, lordship. But they have done one thing, lordship. Without the giving information to the family members, they have done the postmortem report. Postmortem, lordship.
Who has done postmortem?
They have sent it for postmortem, and the postmortem was done without giving any information to the family members of the
That must be the fault of the police.
lordship.
Learned counsel for the petitioner. And also learned additional PP. CDS called for has been received. This is an application under so and so. It appears from the information lodged by the petitioner before the OC Bhorul Biswanath Sariali PS dated 2/8/2025 that the deceased committed who was undergoing treatment at the rehabilitation center of the petitioner suddenly ran towards the top floor of the building and jumped to the ground, as a result of which he died. Subsequently, the father of the deceased lodged an FIR on the same date.
After some time.
Where is the father's FIR? Page
Lordship,
24.
It is at page, lordship. Page 31, lordship, not on the same date, lordship. After 3 days of the alleged incident, lordship. Page 31, annexure G, lordship.
Same date, na? After 3 days. Page 38.
31, lordship, annexure G, lordship. Lord.
Alleging that the deceased may have been killed and also that the postmortem examination was conducted without their consent, without any information to the informant. There appears to be no material in the CD implicating the present petitioner. And the PM report is also consistent with the information submitted by the petitioner to the police on 2/8/25 as indicated above. Having regard to the above, the prayer for pre-arrest bail is of 20,000 on security. Conditions cooperate with the investigation. Shall not try to influence the witnesses in any manner. Yes. Yes.
We have not, he, in time, we have not received a case diary.
Received?
Not received, he is an interim.
Already. So did not receive list again of so and so.
25/11.
Interim order passed earlier to continue till the next date of listing.
This is also lordship, we have not received a case diary.
But I am not interim law.
You are on interim?
Not in time.
Not in.
Sorted lordship.
Sorted law.
Already. When?
17 lordship, 17/11.
May I please, your lordship? Your lordship will find the FIR mallet page 9 mallet. Type of. Mallet.
Not received.
We have received a case diary lordship, but.
But what?
Going to the case diary, it is very difficult to ascertain whether these petitioners are implicated in investigation in initial stage. They were arrested from other cases, but police identified one person in CCTV camera. But going to the case diary, they are home search, but nothing found in the case diary whether their implications are there or not. So my humble prayer before lordship, even a short time, I will send back the case diary and after because they may be called for about the investigation lordship.
That case, my lord, I am praying for interim, my lord, because, my lord, they are from West Bengal, my lord. They never visited. It's a case of 2024, my lord. Kindly see, my lord. The FIR raised, FIR date, my lord, 2/5/2024, my lord. And, my lord, they are at that point of time, my lord, they never visited, my lord, Assam, my lord. They are from West Bengal, my lord. My lord, and the allegation, my lord, in the FIR, my lord, one person entered into the bank and snatched away the bag of the informant, my lord. And subsequently, the IO, my lord, paid for adding section 395, my lord. If I, my lord, we go through the, my lord, section 395, my lord, 5 or more persons, my lord. 95 will possibly not come, my lord. 379, if we believe the FIR, my lord. My lord, they are not at all there. Well, I have categorically mentioned in my petition also, my lord. At that point of time, they never visited Assam, my lord. They are from West Bengal, my lord. After they were arrested in a case, my lord, different case recently, my lord. They were wanted to show them arrest, my lord. They made a prayer before the learned court below, my lord. So that prayer also rejected by the learned court below, my lord. I have annexed, my lord. So, my lord, if, my lord, they want up-to-date case diary, my lord, then I pray for interim order, my lord.
My humble prayer is that I will communicate with the IO lordship what is the status of the investigation lordship and their implications in this case. So given a short date lordship, we'll try to communicate to IO and produce the case diary with updates on lordship.
Because it's not a new case, my lord, it's a 2024 case, my lord. Because at this stage, but if there is no material, my lord, finally interim protection, my lord, and they produce the updated case diary, my lord.
The petitioners are not from the Assam lordship, they are from.
I will cooperate, my lord, go there and record our statement, my lord, during interim, my lord.
One is.
Will cooperate, my lord.
Jalpaiguri, West Bengal.
All are from same village.
Jalpaiguri, West Bengal. Lordship.
All are from same village. Kindly, my lord, that part, my lord.
Earlier one is they were in custody earlier.
Yes, they granted.
Where is the rejection order of showing arrest?
Well, that is page 16, my lord. Page 16.
It was for formal reason, it was not.
But my kindly see, my lord, the FIR said 1%, my lord, and they prayed for shown arrest for 4%, my lord. And my lord, I have mentioned in my petition also, my lord, they have not even visited Assam at that point of time, my lord. It is a case of 2024, my lord. And at that, my lord, they have not found anything against me, my lord, in the case diary. They said that the initial stage, my lord. So, my lord, I prayed, my lord, we have been protected, we will appear before the IO and record our statement, my lord. It will help the investigation also, my lord.
What will you state before the IO?
My lord, they will appear, my lord, and record their statement, my lord, because in that, my lord, kindly see, my lord, 2024 case, my lord. I have mentioned, my lord, in my petition, my lord, paragraph, my lord, 4, my lord, page 5, my lord. They have never visited Assam at that.
Then let us have it on Tuesday.
Lordship. Tuesday, it is Lordship, 11.
Get the instructions.
11 milligrams. Okay.
Protection, my lord, kindly, my.
That's for Tuesday only. We'll wait for that.
Obliged, my lord.
Hey, please.
Yes, sir.
But FIR is at page number 14, my lord. All the allegations are against the husband of the present petitioner, who accused. There before your lordship is the accused number 2, who is the wife of the accused number 1. My lord. FIR is at page number 14. my lord.
Receive.
Yes, sir.
Page number
14. From 15 it is started, my lord. Allegation is about defrauding of 13,50,000 rupees, which was deposited in the account of a NGO, which is owner of which is the accused number 1, husband of the present petitioner. So the petitioner is incorporated as an accused number 2, my lord. The FIR, there is no such allegation against the present petitioner. Except one line.
After going through the statements, Lordship, allegations are against husband, Lordship.
against.
Husband, Lordship.
What is the specific act attributed to them?
My lord.
heard learned counsel for the petitioner. This is an application under strength, so the allegations as contained in the FIR, briefly stated, pertain to commission of cyber fraud by certain persons, including the husband of the present petitioner. Who have been defrauding different persons by using fake bank statements, it is submitted by prosecution that upon perusal of the CD that the materials available therein are against the husband of the petitioner. There is no such incriminating material against the present petitioner. Having regard to the above, the prayer for pre-arrest bail is allowed. And 20,000 once year conditions, cooperate with the investigation. Shall not try to offend.
Receive. It's a 482 application. Lordship, the FIR is at page 8.
Lordship, here CD receipt, but Lordship, the first documents has been sent to Seva board for Lordship, ascertaining the documents are forged or not, Lordship. That report, it is not there in the case diary, Lordship.
In this regard, Lordship, the election petition is the appropriate forum, Lordship, and the DC has already taken action against the petitioner, Lordship. So interrogation is, interrogation is no longer required, Lordship. Moreover, on receipt of the notice, Lordship, the petitioner appeared before the IO, and Lordship, formally her statement have not been recorded, Lordship. So this is only the case, Lordship. During Panchayat election, Lordship, the petitioner submitted matriculation certificate, Lordship. That certificate have been considered as false, Lordship, and accordingly, appropriate application was filed before the Deputy Commissioner, Lordship. And Deputy Commissioner has already taken action, Lordship. Same itself is reflected in the FIR, Lordship. And Lordship, there are some co-accused, Lordship. The court below has already granted bail to the state accused, Lordship. So, Lordship, earlier my interim prayer was not considered. Moreover, Lordship, one same petition was considered by this honorable court, Lordship, a coordinate bench of this court, Lordship. Lordship may kindly.
So the only allegation is regarding
Submission of false document.
So that is the proper authority on documents. They will.
And I will cooperate, Lordship.
There is nothing to interrogate now.
Same allegation, on same allegation, Lordship, bail have been granted, Lord.
Already heard Mr. Chancellor Learned Counsel for the petitioner also heard learned additional PP. Decision application. It, the gist of the case is that similar order associated phase 2 tick mark text in India. You are not an elected member, are you?
I am the elected member lordship and my candidature has been state lordship. By the deputy commissioner lord.
Elected member of
Panchayat ward member lordship. Lordship, there are 3 of my petition lord. Ward member from Baijar Alga part 2 under 23 number Doksin Baijar Alga Gaon Panchayat. I hold the election.
3 of the bill petition type like correction. It appears from the above that the principal allegation is regarding falsification of documents. It is submitted by learned additional PP that as per the CD, the state documents have been sent to the concerned authority, that is Secondary Education Board, Assam, for verification. Also, therefore, it appears that the custodial interrogation of the petitioner is not necessary. Co-accused of this case has been granted bail by order dated 4/11/25 AB 2541 of 2025. Granted pre-arrest bail.
May I interfere, your lord? Lordship, 4/11/2025 is not the co-accused lordship. Co-accused bail is next at page number 12. 12 of my petition lordship by the court below lordship. This order was passed in same allegation lordship in different case lordship.
The page number?
Page number lordship 12. Page 12.
By order dated 9/9/25. In miscriminal case number 929 of 25 passed by the learned additional session judge Dhubri. There are having regard to the prayer for pre-arrest bail is logged. Is provided that in the event of his arrest in connection with the aforesaid case, the accused petitioner released on pre-arrest bail on furnishing bail bond of rupees 30,000 with a local surety of like amount to the satisfaction of the arresting authority. The following condition. I got order to take executive tick mark here, so paragraph एक detail है वो. Conditions के तो तारे बोले. Master Lordship.
CD not received, Lordship.
Yes, sir. Huh?
Not received.
Madam, 106 RDR 108, abatement of suicide. Page 10 is the FIR. They were in a relationship there, madam, marriage proposal was going on. Some demand of dowry, that is the allegation prior to the marriage. Thereafter, she consumed poison.
Let me call. 12 তারিখ।
What is this? Order dated 13/11/24. High Court.
This is 13.
Page 20, it is mentioned.
Oh, that is murder. His father was arrested.
Father.
Father was arrested. And he was. Our story is paragraph 4, madam.
Yes, when can you get? Is it communicated or not?
It is communicated, Lordship. Order. On 12/11, Lordship.
12.
Yeah, my lord.
All right. Wait on 12th.
12.
Please, your lordship. Is there he was called for mine.
The CD, my lord, just, my lord, come, my lord. So, my lord, maybe after some time, my lord. Item 42, we have received the CD. I please.
Item 59.
Let's be real. For the timing. Kindly taken at two, lordship.
We are saying time being only now. This is item
59, 60 and 61. Time being 59, 60.
Lordship, I am appearing and Lordship, we have taken step of services from and contact but to kindly permit
You are appearing.
Yes, sir.
So and so learned counsel for council has entered appearance for respondent number 2. Hence, list the matter on. Give a date.
May it please your lordship. Lordship, as per order dated lordship, 22/10/2025 lordship.
44 হৈ গ'ল নেকি? Time being.
45.
Yes, 45.
Lordship, as per order dated lordship, 22/10/2025 lordship. We went to the house of the respondent to serve the copy through Dusty lordship. But she did not receive the copy, lord. In this regard, we want to file an affidavit, lordship.
Learned counsel submits that he would file an affidavit regarding justice service. Hence, please the matter.
Can it be on lordship 20 lordship,
Already.
2011 lordship? Oblige your lordship.
This not done again. Service to complete. Because office note service is awaited. Not showing as an awaited, but service was taken, they have taken steps, but whether service is completed or not, that is not reflected in the office note.
But would have taken it on 2/8/2020.
As per 2810, that is TCR received. Earlier that services notice was issued and steps taken. After that, regarding service of notice, no office was there.
My lord, the section is called for section 10, my lord. The conviction here is 5 years. And already, my lord, more than 1 year in jail. The judgment was passed on 26/6/2025, my lord. And earlier, my lord, during trial, my lord, he undergone 8 months, 3 days. And all total, my lord, more than 1 year. Sentence is 5 years.
44 petition.
So, my lord, I am paying for bail.
What is the address of respondent number 2? Where?
Two is Boniabari, Alif Nagar, Shivsagar, Shivsagar. Boniabari, Alif Nagar, Post Office, Shivsagar,
district Sibsagar, police station Sibsagar. Right? In the That is FIR, written in FIR also, my lord. Case 16, Koniabari, Alif Nagar, Sibsagar. Is there at the
Should have been served by now. When did you take steps?
my lord, we take a step on my lord 28/2025. 28/28.
So what to do?
For us to some application. Lordship, we can want, Lordship, we have taken instruction whether this must be served or not from the concerned police station, Lordship. So,
Office note does not indicate anything regarding service of notice on the respondent number 2. Learned additional PP to obtain instructions whether respondent number 2 has been served to concerned police station. And if not, then to cause service through said police station.
after sub completion of service, they are nahi 21/11, Lordship.
Right, ma'am.
Yes, yes.
Received.
He was called for.
Received, Lordship.
The FIR, Lordship, may kindly see at page 13. Allegation is that we took part in collecting money in the name of PMAY survey from different people. Now, this survey can be conducted two ways, through an app. An intending incumbent may download the app and the procedure is laid down in the app, how to follow it. Your Lordship will kindly see it at page 14. And it starts from page 15.
What is this about collecting money?
No, so far as our statement on affidavit is that both the persons mentioned in the FIR are the two petitioners before your Lordship. They were exchanging money amongst themselves. No third party was present. We were exchanging money amongst ourselves for some purpose. We have said, the petitioners have said that it is for the purpose of, he was exchanging 500 rupees for the purpose of refueling the motorcycle. Now, for the purpose of PMAY registration and survey, there is a detailed procedure laid down by the government, and it has to be done through app. Of course, it can also be done through field officials, but the field officials have to be the authorized persons of the department. The field official has to, if a field official visits a particular person and wants to activate the process, then he has to identify himself in the system through biometrics, and then only the process can be done by the field official. It is not just that somebody comes to my house, asks for registration, and I give him money or he takes it and there is done. Your Lordship will kindly see page 15. The procedure is laid down there. Even if I am a field official, I can collect the money and I can activate the process only if my biometrics are true.
Yes, PP, what is
Lordship,
there?
yeah, Lordship, a video was viral and telecast in a news channel also, Lordship.
that they are taking and demanded money from the beneficiaries who are granted PMUL only by the name of geotaking. That some witnesses are stating that yes, they have demanded money. One of the witnesses stating that he has not specifically implicated, but specifically Genfuta have flag marked it. Someone is stating that yeah, they have heard about that they are demanding money and taking money from the beneficiaries.
Hearing something, and somebody being deceived, coming to the police, it's a
From
different thing.
the video viral and telecasted in a news channel, that FIR was lodged against them. Lodged.
He also did not see anything.
Yes, but the video was there. Video was on the pen drive, Lordship, but they are doing that. He also not stating anything against that. They are. He's viewing that they are taking money, Lordship. Other witnesses are there, Lordship. Only I have to pray, Lordship. Let him appear before. Let them appear before the IO, and if anything reveals on the further investigation, Lordship.
So what, we have to keep his pending?
Pending then.
All right, hard learned counsel for the petitioner and learn additional PP. TDS call for has been received. Learned additional, he submits that the petitioners may be directed to appear before the IO for recording of their statements. Until then, the matter may be kept pending. Accordingly, it is provided
Well, may
that
I just
the
interject?
petitioners shall appear before the IO within 7 days from today for recording their statement, and in the event of their arrest, they shall be released on interim pre-arrest bail of rupees 20,000 with each, with one surety each for like amount, to the satisfaction of the arresting authority in connection with the aforesaid case. List again
26/11.
on 26/11.
Can it be some accommodation with the date? Instead of 26th, if it can be on 27th. Obliged.
Please, Lord. These three petition were not out of same FIR, my lord.
FIR is at page 14, my lord. Event portion on page 15. That was filed by one sub-inspector. my-
Here rejected, no? One eye. I guess it's like it's like case got rejected. Telling me. That's
Yes, PP.
my lord, CD receipt, my lord. Here, my lord, in this case, my lord, the another two co-accused is already arrested, my lord. Now, my lord, prima facie, my lord, sufficient materials are there. The case, my lord, there is a gang, my lord, racket, along with that Gaon Bura. The Gaon Bura is already arrested, my lord. They are taking the advantage of those some people, my lord. Now, my lord, that is the Aryan Kumar, whose name is there, my lord. All these are FIR name accused, my lord. He from his lead after interrogation, police find him that he is actually a victim, my lord. These people are taking money from this way, my lord. My lord, may kindly produce the CD, my lord. The relevant parts I have flag marked, my lord. His, my lord, 183 statement is also taken, my lord. Amount of 6 lakhs is given. So, my lord, this is not a case of single case of this particular person, my lord. From it is a, my lord, investigation is still going on. So, my lord, this PRS is, my lord, our humble prayer is that, my lord, not at this stage, maybe, my lord, granted. Because, my lord, in those cases, my lord, custodial interrogation is very much required, my lord.
But in the
All are
FIR, my
FIR
lord,
name accused, my lord.
the FIR, my lord, the Aryan Kumar is the candidate. He obtained, my lord, PRC with the help of, my lord, one Pinku and Gaubura. They were arrested. All these 3 persons arrested.
You are Jitendra.
Yes,
Yes,
my
my
lord.
lord. All are FIR name.
All are there.
My lord, in the FIR, my lord, my involvement, my lord, the Pinku's sister, my lord, is residing near my house. So, my lord, he is, my lord, known to me. And there is no transaction, my lord, with this petitioner.
FIR may not reveal everything,
Yes.
but in the CD, you feature quite prominently, it seems.
Yes. And even in the FIR, my lord, in the para 2, my lord, there is the after interrogation as per state of Aryan Kumar has stated that he has taken the PRC from one Anand. That is, my lord, there is a petitioner number. My lord, in the case of my lord, he is Anand is item number 60, my lord. So, my lord, Anand, my lord. Anand had put him in touch with Pinku Sohan, Jitendra Sohan, and Birendra Sohan. All are before your lordship, my lord. Jitendra Sohan and also my lord Birendra Sohan, my lord. So, my lord, these are the cases, not only case of a single person, my lord. The gang racket, my lord, still they are working, my lord. So, not at this stage, my lord. No, my lord, investigation is, my lord, progressing by this, my lord. But, my lord, to find out everything, my lord, their custodial interrogation is required. And here is a case, my lord, where, my lord, it is filed, my lord, that is the SI, my lord, of the police on the basis of a, my lord, that is information upon receipt of the DC office, Huzai, my lord. On the basis of that, my lord, information.
They all see the list. But in every, my lord, 2168, my lord, Birendra Sohan, my lord, he is also candidate, my lord. He also applied for PRC, my lord. In that, my lord, while he was moving, my lord, his application, he came into contact this Pinku, my lord. So his name has been inserted in the. He himself is a candidate. His age is about 22 years. He applied and he was moving his application. Or bank statement has also ceased, my lord. The statement, my lord, is clear that we have paid, my lord, not any amount has been deposited in our account.
Aryan Kumar,
Yes, my lord.
Aryan Kumar is candidate.
তেওঁ পিংকু চৌহান, জিতেন্দ্ৰ চৌহান আৰু বীৰেন্দ্ৰ চৌহানক অনলাইন ফোন পে যোগে এই ধন পৰিৱেশন কৰিছিল। Third learned counsel for the petitioner, learned additional PP. This is an application under so. The principal allegation against the petitioners is that he is involved in arranging fake permanent residence certificates for aspiring candidates who wanted to obtain employment in paramilitary forces under the quota meant for the candidates from some para on perusal of the CD. I find sufficient material against the present petitioner warranting his custodial interrogation. Accordingly, prayer for pre-arrest bail stands rejected. Send back the CD. Same order, all three cases, 59, 60, 61.
All right.
My lord, with all respect, my lord, this court, sorry, my lord, this case lordship has dealt with, my lord. Certain ladies were granted the privilege of bail in an arson case. Here, what has happened, my lord, if I read the FIR in totality, my lord, I am the owner of that particular plot of land wherein nearby my house is situated. My house has also been burnt, a portion of it, my lord. And there is another tenanted premises of ours, my lord, nearby M Bazaar, my lord. M Bazaar, these are chains, my lord. That house is also burnt little bit. And if I read the FIR that occurs at 20, allegation is, my lord, at night it got burned down because of Diwali crackers. And therein, my lord, with all respect, I would submit, my lord, no specific allegation that the male persons have burned down the house, my lord. Only, my lord, they are also suspecting that it may have been burned down. If I read page 20, one paragraph is apparent enough, my lord. Kindly see page 20. And there are 6 ladies here also, my lord. Page 20. Lordship may have found, my lord.
Yes.
With all respect, this is hereby to inform you that on so and so at around so and so, Mr. Sethi Motorcycle Scooter Works, situated at Kosaigaon Tibet Center, was deliberately, can you see the language, my lord? Was deliberately got burned down into ashes with a criminal inspiration conspiracy by the landlord. No allegation that we have burnt it down. Owner of the shop, namely, these three are named, my lord. They are also petitioner along with 6 other ladies. Leaving aside 5 lines, kindly see. But in spite of our best effort, we could not be able to find out a new place for shifting our said garage. Garage is the bone of contention, my lord. We also had requested them, meaning thereby us, my lord, to help us in finding out another place for shifting our shop, but they also failed to do so. These are the allegations, my lord. Now kindly come to page 9, para 9. This is our part of the story, my lord. Page 9, para 9. Can I read it, my lord, with all respect, my lord?
Yes, yes.
Page 9, para 9. That the petitioners beg to state that unfortunately during Diwali, on intervening night of 21/10/25, 22/10/25 at around 1:52 am, when the family members of the petitioner number were sleeping, the neighbors started to make hue and cry when the petitioner number 1 went out on named in the affair, my lord, saw that a fire had broken out in the plot of land adjoining the petitioner's number 1's house. Nobody will set fire to a house which adjacent to his own house. His house would also get burned down. Immediately, the petitioner number 1 called 101 for informing about the fire. Thereafter, the elderly people and the children of the petitioner number were evacuated, and the petitioner number 1, along with help of neighboring people, removed the cylinders from the house of petitioner number 1. In the meantime, 2 fire engines came and started pouring water on the fire. Due to the fire, the petitioner number's 1 house was also damaged, and even 1 building, namely M Bazar. M Bazar is a chain, my lord, owned by the petitioner number's 1 uncle-in-law, also sustained fire damage. The petitioner number 1 also informed the police by calling 100. Thereafter, the petitioner number 1 and also informed petitioner number 2 regarding the incident, and the petitioner number 2 subsequently arrived at the alleged place of occurrence. Furthermore, there is no reason as to why the petitioner number 1 family members would set fire to their own property, as not only the informant's tenanted premises, but even the house of the petitioner number 1 and the building, namely M Bazar, had also sustained damage in the incident as such. This is our prayer, my lord. And 3 are, my lord, with all respect, my lord, male persons named in the above, nobody saw them setting the house on fire, my lord. If I read the affair in totality, and there is, my lord, with all respect, my lord, if I set fire to that house, which is just adjacent to my house, my lord, my house will also get burned down. And because it is an accidental fire, my entire house was not burned out, some part was burned down. And even the house garage, my lord, the entire garage was not burned down, some part was burned down. And next to it, there is another building with tenanted premises, my lord, M Bazar, which pertains to my relative, my lord. That M Bazar is also partially burned down, my lord. This is the situation. With my lord, if there are materials in the case that I am away from police, my lord, lordship would definitely reject it. But at this stage, on the allegations, with all respect, my lord, nobody saw them setting fire to the house. The language and tenor, my lord. My lord, the only suspicion, my lord, that this is our case, my lord. Kindly protect, and if there are materials, definitely, my lord, lordship would reject it, we will surrender. And if necessary, we will come to court on the next date when the CD comes. If there are materials, I can be picked up from here also, my lord. This is our case, my lord. I do not know what the state says. And FIR is at, in totality, page 20, my lord. And my case is at page 9, para 9. The rest are all ladies, my lord. Only 3 are named. Others are bailable offences, my lord. If the FIR is read in totality, my lord, no specific direct allegation, ocular evidence that somebody saw us setting fire to the house, my lord.
Yes, maybe.
That's okay. Everything will reveal from the case. What is their involvement or not, lordship?
Protect, my lord, with all respect. If there are materials, my lord, we will surrender, my lord. One thing is sure, my lord, no specific allegation that anybody has saw us setting fire to the house.
Still, Mahajan learned counsel for the petitioner and additional PP. There is an application on praying for grant of bail in respect of the present petitioners, namely petitioner Kiran Namdi people. The allegations as reflected in the FIR inter alia are that on 22/10/25, Tarago call for the CD at around 2:10 a.m. The complainant's shop was deliberately burned down by the present petitioners. Full stop. Para. It is submitted by learned counsel that on a plain reading of the FIR itself, it would be apparent that nobody actually saw the petitioners committing the act of arson. It is further submitted that the petitioner's own house is located adjacent to the rented premises. The premises rented out to the complainant, and therefore the petitioners can hardly be expected to set the adjacent house on fire, as it would affect their own house as well. Para. It appears that the petitioners have been named in the FIR on suspicion due to prior dispute regarding possession of a garage being operated by the complainant. Having regard to the above, it is provided that the petitioners, in the event of their arrest, shall be released on interim pre-arrest bail of rupees 20,000 each, and surety each for like amount, satisfaction of the arrest in connection with the aforesaid case. It is further provided that the petitioner shall cooperate with the investigation and appear before the IO within a period of 7 days from today, and that the petitioner shall not try to intimidate or influence the witnesses in any manner. Release the matter again on
26/11.
Highly obliged, Malik. Obliged, Malik.
Article Lordship, we have received an instruction from our office that on 29/10/2025, Lordship, the CD was taken from by the IO Lordship, from our office, Lordship.
The last two occasions CD received. We
Now,
have
if the CD was here, why was it not taken up then?
service report was not completed. Now, Lordship, service report is completed, CD is not.
On 29/10, it was taken back from our office.
Well, we need it then.
Protection, Lordship, may be given. I am waiting for long. He's a manager, Lordship, manager has done this thing. Case 10 is the FIR. And present petitioner is the owner of the Lordship.
Already it is submitted, not who is appearing for respondent? You, Mr. S. Ahmed, learned counsel appears for respondent number 3. Oh, 3 is already appeared on the previous date. Your name is?
S. Rahman.
Sir S. Rahman, learned counsel, has entered appearance for respondent number 2 and hence service. What about 4?
Appearing,
Huh?
4 also.
4 also.
Appearing, respondent number 3 and
Or 3 and 4.
Who is the police officer?
Service on all the respondents are. Respondent number 2 is represented, being a police officer, is represented by learned additional PP. Service on all the respondents are complete. However, the CD, though received earlier, has been taken back by the IO. Hence, call for the updated CD. Release the matter again on
17/11.
17/11.
17.
17.
POXO is there,
Yes,
So-
Lordship, Fox.
6, 17.
My lord, in this case, my earlier occasion, your lordship has asked the government side, take my lord status of that.
Yes, status.
Received the status report, but. Okay. It submitted.
Charge is submitted.
After some time, Lordship, we have received the instruction on that date, Lordship, earlier date also. We have. Not received.
Yes, next.
But yes.
LCR, my lord.
Hmm?
Kindly, LCR may be called. Charge it.
Let him
Current-
already.
Apply. After some.
Yes.
My lord, here, my lord, as per the last order, your lordship, a status report was called from learned PP, my, from the concerned police. That's why it was fixed today, my lord. Person is.
Yes.
My lord, some time may be given, my lord. We'll take the instruction.
All the timing. টাইমিঙৰ বাহিৰে বাকীবিলাক হৈছে খিনি অৰ্ডাৰ্ছ খিনি
LCR, my lord, may be called.
Huh?
LCR may be called for.
FR submitted on by number 140/25 dated 36/2025 on June month.
So by now notice to complainant must also be over. You ascertain from there.
My lord, may I pay, my lord, matter may close, my lord, with the liberty, my lord, if the complainant proceed, then he
Not-
may approach me.
Yes, all right. Heard learned counsel for the petitioner. Learned additional PP submits that FR has been submitted in this case on
On by FR number 140/25 dated 30/06/2025.
hence this matter is disposed of with the observation that in case the FR is not accepted by the learned court below, petitioner will be at liberty to approach this court afresh.
Diploma.
If also we have received the instruction, services completed, so that Michael can be appointed.
Is submitted by additional PP that on PP on instructions received that service under respondent number 2 has been completed. Accordingly, so and so is appointed as amicus to represent the respondent number 2 as none appears for the said respondent.
It may be fixed.
List. Copy of the petition be served upon the amicus list. Again on
28.
Your lordship had already heard about this issue, my lord. The non-compliance of 42 is concerned, my lord.
Basically, my lord, the case was that, my lord, around 18 bottles of cough syrup were allegedly recovered from the house of the appellant. Now, my lord, this recovery was made post sunset. Now, P42 says that once the empowered officer receives any information, oral information, he will have to record the information and then he will proceed for search and seizure. But if that search and seizure is made after sunset, then you will have to record the grounds, and both the grounds as well as the information will have to be passed forwarded to his superior authority. Now, here Lordship will kindly see Exhibit 4. Exhibit 4.
Is the record?
Record received, Lordship, but not on for it. Earlier part, it was kept part hard, Lordship. Yes, sir. Okay, but
Exhibit?
Exhibit 4. E4.
Yes.
So they have mentioned that this is the compliance of section 42 of the NDPS Act, but no grounds have been mentioned. The Honorable Supreme Court in various judgments have clearly said that if this was delayed, then substantial compliance was there, but total non-compliance is impermissible. Here it's a case of total non-compliance, my lord. The grounds should have been mentioned, but no grounds have been mentioned, my lord.
So this is regarding seeking of authorization.
Yes, but in the subject matter, they have mentioned that this is the only compliance, and even if it is evidence, he has said that the compliance was Exhibit 4 only. Other than that, there is no other compliance report or compliance information.
That was the only point.
There are other points as well. If your lordship is satisfied on this, but I am not going to take up the other points. But this goes to the very root of this matter, man.
My satisfaction will come at a subsequent date.
Yes. Well, if your lordship will kindly see section 42.
Yes.
42, may I read? 42 proviso.
NDPS. NDPS.
Proviso of section 40.
Yes.
Provided further that if such officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of an offender, he may enter and search such building, conveyance or enclosed place at any time between sunset and sunrise. So after sunset, after recording the grounds of his belief. So he will have to record this.
In the present case, what is the time?
2 o'clock, 2 a.m. my lord, night.
Okay.
And then it says that where an officer takes down any information in writing under subsection 1 or records grounds for his belief, these are the grounds, under the proviso thereto, he shall within 72 hours send a copy thereof to his immediate official superior. So both the grounds as well as the information will have to be passed on to the superior authority within 72 hours. Supreme Court says that if it is delayed, all right, no problem. But total non-compliance is impermissible. That's what has been laid down in Colonel Singh. If your lordship will kindly see the judgment of Colonel Singh.
So in exhibit 4, no ground has been
No
mentioned
grounds have been
as to
mentioned.
why search
Yes.
at night is necessary.
Yes.
What's the officer conducting the search?
Suit of Rajasthan versus Jagraj Singh, I have placed
In the
last
present case, what is the rank of the officer?
rank, my lord, SI.
Yes.
Jagraj Singh, my lord. At para number 29. Last page. Last page.
Yes.
After referring to the earlier judgments, the constituent bench came to the conclusion that non-compliance with the requirement of section 42 and 50 is impermissible, where a delayed compliance with satisfactory explanation will be acceptable compliance with section 42. The constituent bench noted the effect of the aforesaid two decisions in para 5. The present is not a case where insofar as compliance with section 42(1) proviso, even an argument based on substantial compliance is raised, there is total non-compliance with section 42(1) proviso. As observed above, section 43 being non-attracted, search was to be conducted after complying with the provisions of section 42. We thus conclude that the High Court has rightly held that non-compliance with section 42(1) and section 42(2) were proved on the record, and the High Court has not committed any error in setting aside the conviction order. Here, my lord, the Supreme Court relied on the constituent bench judgment in Karnail Singh, my lord.
So this is Colonel Singh.
Karnail
Same.
Singh. Karnail Singh, my lord, para number 32.
All right. Anything on this point, PP?
Chief, only thing is that as in the judgment of 44, page 44 of Chief, in number 32,
Page 44 of?
page 44 of the main petition, Lordship. Upon further perusal of the said GD is Lordship found it of main petition. And
Yes.
upon further perusal of the said GD, it can be observed that all the relevant details about the secret information received by PW1 was informed over phone to various authorities, including SP Dhubri, who in turn instructed PW1 to acquire authority letter from Deputy SP, headquarters Dhubri, which was duly acquired by PW1 for Shankar Mandal. The said authority letter is duly exhibited at Exhibit P3, PW1 provision of section 42(2) of NDPS Act is to inform the superior authority in writing about the detail of secret information and other relevant details to the superior authority in order to roll out any concocted case made against the accused person. In this instant case, the reference DDS number 194 to 11/4/23 is specifically mentioned in Exhibit P4 PW1. While communicating the information to the superior authority by PW1, it gives the information to the extent to GD number 194 dated
11/4/23 is duly made in connection with the instant case. Exhibit P4, PW1 was communicated to the superior officer on 11/4, that is on the same day.
Where
of
are
the
you reading?
Page
Page
43 of the appeal memo.
43 of the 43 and 44, all of you. Appeal memo. That's why that is why the same day of the incident. Therefore, I am the opinion that there is a substantial compliance of section 42(2) of the subsequent 2 of the NDPS Act, Lordship.
It makes reference to the GD entry, but is the GD entry available to the superior officer at that time?
Lordship.
The question is, what would amount to substantial compliance? Merely mentioning the GD number, is it substantial
Since there are
compliance?
two parts, information and the ground. Here we are not disputing about the information, but regarding the grounds, that part is not there.
Where is the GD entry?
GD entry is exhibit 1.
Even in the GD entry, ground is not there as to why it was to be done at night. Yes. Anyhow, what other points you
Other
had made out briefly?
Other points, my lord, this substance was not exhibited, material evidence.
But what about section 52A?
52A is also not fully complex, partial compliance is there.
How?
My lord, regarding 52A, inventory should be there. Then list of samples will have to be drawn, photographs will have to be made. Here in this case, my lord, photographs are not there. Plus, if this contraband were not exhibited as material exhibit, these two things are missing.
Now, if we go by 52A, it's not necessary to exhibit the bulk of the material.
It, my lord, if there is some, my lord, if the thing is that if the seizure is disputed, or if there is a case, my lord, where 52A has not been complied fully, then, my lord, in that case, my lord,
That can be cured by exhibiting the material.
yes, it's a recent judgment, my lord.
Yes.
The recent judgment, my lord. Para number 33. Para number 31.
31.
31. In the light of the discussion above, in our view, mere non-production of the seized contraband during trial may not be fatal if there is reliable evidence in respect of his seizure, drawing of samples therefrom, and FSL report relating to the sample drawn from the seized material. However, to ensure that no adverse inference is drawn against the prosecution for non-production of the seized contraband, documents prepared in terms of the provisions of section 52A, inter alia evidencing preparation of inventory of seized contraband and drawing of samples therefrom would have to be brought on record. So there must be evidence as to how the inventory was prepared and how these samples were drawn. Here in this case, madam, there are no evidence, madam. Then likewise, evidence should be there that the sample drawn from the inventory was sent to FSL in a sealed container envelope as per the guidelines, and that the seal was found intact at the end of FSL. This is to obviate any doubt regarding sample being tampered in transit. Similarly, FSL's report, along with the sample tested by it, is to be placed on record. So the sample will also have to be exhibited so that there remains no doubt regarding the sample tested. So on the first thing is that the seals are to be exhibited. Then, my lord, the sample from where the testing was done, those samples will have to have exhibited along with the FSL report. Here, my lord, neither the FSL report has been exhibited nor the samples. FSL report has not been exhibited, and the FSL, the officer, scientific officer, has also not been examined.
Then how was it proved that it was a contraband material without producing the
It's
FSL?
a scientific, as per 294, perhaps CRTC, presumption can be drawn as to any report.
No, you are saying it was not exhibited.
It's not exhibited.
Then?
By the scientific officer was never examined.
So the IO must have exhibited.
The exhibits column, my lord, it is not there.
See the evidence of IO?
IO, my lord, PW5. He has exhibited the sketch map, the seizure list, the inventory, the list of samples, and the forwarding report. That much.
And the most basic requirement is missing, it seems.
Yes.
How does one know that this is a prohibited drug in the absence of any scientific evidence? See prosecution if it has been exhibited somewhere.
Lordship, in the, my lord will kindly see the page 51, the appendix, all the exhibits. My lord.
Sometimes it may miss out also because there, but in the main evidence it may be there. But other than the IO, who would exhibit it?
Lordship. Only IO can examine.
Let this part is maybe completed, might be completed, Lordship, and I will go to the cascade again, the TCR, Lordship, and we'll submit our part, Lordship. What a complete, I can. Hold over here. Hold on, Marty. Take. Ini আছে ক'বলৈ। এইটো কালি আছে আজি চাই থম।
Yes. That is all.
Normally, my lord, thing is that when a contraband is seized, the IO will steal it and then hand it over to the officer in charge. Officer in charge will keep it in the Malkhana. So that Malkhana register will be there. And thereafter, my lord, from there will be produced before the magistrate who will draw the sample. So this entire thing, my lord, should be on record. How the inventory was prepared, how the seals were attached, how the seals were opened. These seals, my lord, will have to be exhibited. Thereafter, my lord, the samples, some samples will be kept as primary, some samples will be sent to the FSL. This entire procedure, my lord, will have to be brought on record, and plus the seals, my lord, which were put in, affixed by the officer in charge as per section 55 of the NDPS Act, that will also have to be exhibited. Then, my lord, as per this judgment, the samples that were sent plus the report, those report will also have to be exhibited, will also have to be brought on record that these are the samples from which were tested for contraband. Otherwise, it can be that some during transit, some different samples were tested or different samples. So to remove any doubt, the entire chain of custody, the entire chain,
Remnants of the
yes,
samples.
will have to be brought on record. Here, there is no evidence.
Yes.
And there is another judgment which I'd like to place, Jitendra and another, which says that it was the best evidence are the seized materials, which has been discussed by and placed. Normally, my lord, in this kind of cases, my lord, the best evidence is the materials itself, the contraband, and that was not exhibited in this case.
And this is a case of 2004. Thereafter, 52A was enacted to get over the problem of custody of these seized materials because of their misuse.
Yes.
Now the law is that they should be disposed of as expeditiously as possible so that they cannot be used for other purposes.
Being the samples.
Yes.
The remaining can be disposed of.
Yes, that is
keeping the
what.
samples. So samples. will
So
also
the
be-
whole seized materials cannot be exhibited in
Yes,
court.
but the samples, my lord, could be exhibited. The samples which are in the record,
Yes.
the record room of the court, that will also have to be exhibited if there is any to remove any doubt regarding the seizure. Say, for example, the witnesses turned hostile. In those cases, to remove any doubt, this seized material, the primary sample must be exhibited. So that is one, my lord, my line of argument. My lord. So, and another aspect is that, my lord, the independent witnesses, my lord, there are no independent witnesses, my lord. All the witnesses, these are witnesses, BDP personnel, man, working under the federal police.
Yes.
So that also creates a doubt with regard to the seizure of the contraband. And one also, one more aspect is that, my lord, there is no evidence regarding the ownership of the house, that this house belonged to the appellant. No identification, nothing. The IO could not say that he knew from some source that this house from where this contraband was allegedly seized belonged to the appellant.
Was the appellant found there or not?
They say that he was arrested from his house.
So did you deny that it was your house?
Yes. That was put the IO, the informant, the cross-examination. So Lordship will kindly see the cross-examination, man. He says that there was no ownership document seized or any investigation made from the government official regarding the ownership of the residence from where these suspected contrabands were recovered. I never visited the house of the accused person before the incident.
Who is PW?
PW1, cross of PW, who is the informant.
Informant.
Informant, SI.
That part was for the IO.
Did the preliminary
Because
investigation.
he will like, make the seizure, hand it over to the IO. Rest of the investigation regarding whether the house is owned by him or somebody or rented by him, these are to be during subsequent course of investigation. These are to be
But
noted.
during the process of search and seizure, my lord, there was no input, no information with the informant that the house actually belonged to the appellant.
All right.
That
Yes, PP will take it up after you go it on another day.
Another lordship. I was typing this here and
Had Principal Learned Counsel for the petitioner. Learned additional PP 6. Further time to peruse the record and make his submissions accordingly. Place the matter again on.
Article 11 lordship.
Matter is part heard.
12 11.
will be kept as part of.
Yes.
My lord.
Yes, what is this?
Item number 49. I am for the petition. Lordship.
49.
49. Lordship. My senior has just left actually. He is-
Okoruddin.
Then he is not feeling well, so that left. Another matter, there was also he has taken time. And as per item number 51, Lordship, Mr. B.M. Chaudhary has left. He is not presenting the person.
What is the meaning of left? How can you leave?
Not let actually not attend the court.
Yes, Mr.
So
Bora.
any date next week or
In item number 49, we have already filed, both sides have already filed an argument in 2053. Since then, case pending, 49. Written argument has already been filed by the both parties in 2023.
How are these matters connected?
Minute 40, I am for item number 50, my lord. There are altogether four accused person who has been discharged, my lord. So I am one of them.
So it's the same case.
Same case, my lord. PMLA case, my lord. I have been discharged by the trial court itself, my lord. One more person has been discharged, but he unfortunately he has expired during the pendency of this case. So I am here, my lord, discharged. The rest, they have challenged the order of framing of charge.
Silence the discharge order.
No.
then on the next week or
From 2000 pending for hearing.
for
only
today
one.
only, Lordship, actually,
23,
both of them
25.
has informed us.
Hmm.
Item number 51 and 49 also.
So give us an agreed date then.
17. Actually, I'm not.
Yes, you should inform earlier.
Yes.
Council is waiting since so long. Yes.
And a short date may be given because they have, the order is there, my lord, operating item number 49 and 49 and 50.
It's what I am asking you for an agreed date.
My lord.
I have no difficulty.
Last week of October.
October is gone, I think.
Sorry,
November,
sorry, my
last-
lord. The last week of, no, the midweek of November.
20. Lordship, there is an interim order, Lordship, in item 49.
49 interim order passed earlier to continue.
An appeal, my lord, against conviction. The appellant has been convicted for 10 years under section 6 of POCSO Act. My lord, now issue is that whether the victim is a minor or not, that is the first issue. And if your lordship, the medical report that is at page 28 in paper book. Paper book page 20.
Age?
Page is a medical examination, page 26 starts and 28 relevant opinion.
26.
It starts from 26, 28 is the relevant. That is opinion of the medical officer. Clause 7. Opinion. No sign of sexually. No sign of injury on or private.
You are on the age.
I am on the age. And
so below 18 years.
Below 18. Now question that if he's above 16 years, the Honorable Supreme Court and our High Court also said the margin of error in age is of 2 years.